This matter concerns the remedial action taken by the public protector, and perhaps that's where we should start, to have that remedial action reviewed and set aside. The remedial action, as we would have it, appears on volume 1 of the record, and the particular paragraphs appear on page 353 of the record. If I may invite your lordships and her ladyship to go there. They are indeed also in the heads, JP, correct. There at the foot of the page we have the first remedial action that we propose to challenge under these proceedings. It reads in its language, the President to appoint within 30 days a commission of inquiry headed by a judge solely selected by the Chief Justice, who shall provide one name to the President. Over the page we have paragraph 8.7, which reads that the Commission of Inquiry to be given powers of evidence collection that are no less than that of the Public Protector. The last one is paragraph 8.8, which reads the Commission of Inquiry to complete its tasks and to present the report with findings and recommendations to the President within 180 days. The President shall submit a copy with an indication of his or her intentions regarding the implementation to Parliament within 14 days of releasing the report. Those are the remedial actions that we are seeking to challenge. We propose to organize our submissions not in the same chronology as our written submissions, JP, but rather we have compartmentalized them, and I propose to commence with the standing of the power of the President to appoint a commission of inquiry. The better place to start is to go to the Constitution, and we say that power is located in Chapter 5 of the Constitution, which deals with the executive. It in a sense of what's spelled out in the yes. Powers, the 180 days, the 20 days of the President. The plain reading of the remedial actions presupposes that. But as we will demonstrate later, it is burdened with complexities about it, even if it were competent to happen as the Public Protector had hoped it can. Because the report says that commission, if it is a seat, must get inspired by the issues that are raised in the report. But Justices, I propose that we start, as I say, by looking at what the Constitution says about the power to appoint a commission of inquiry. And to reiterate, we say we find that power is located in Chapter 5 of the Constitution, which is now by tried law the supreme law of the country. 1C will tell us that of the Constitution. It's a power that is described in section 182 bracket 4 bracket F of the Constitution, 84.2F. And might I take us there, Justices? It reads, the President is responsible for, and I go to F, appointing commissions of inquiry. And we make reference in our papers with the founding affidavit, paragraph 21 and 22, on page 21 of those. And we make the obvious statement that this power is quintessentially an executive power. It is an executive power that only the President, according to the Constitution, can exercise. And to exercise it alone without any necessary concurrence with the members of the executive. And perhaps to have a better context to what this power entails, we would refer the court to the judgment of the Constitutional Court in the Sarfu matter. It is one of those judgments that are part of the bundle. With that concession, Judge President, it must then leapfrog us into saying how competent is the public protector to direct and dictate to the President to exercise an executive power. The Sarfu judgment is important to us in a sense that it makes it now trite law that any appointment by the President of a commission of inquiry on the dictate of another is unlawful. And for that reason alone, I do not see, as the JP correctly points out, none of the parties seems to contest that if that appointment is made through dictation, it will be unlawful. They make other different arguments around that point. Now let us examine the question of the separation of powers. Is she competent to then direct the President to hold a commission of inquiry? And in no respectful submission, she's not. We know that to be correct because the Constitution tells us that the public protector is subject to the Constitution and the law. By that, it must mean by definition that the Section 1C of the Constitution, which makes the rule of law part of our foundational values of the Constitution, must entail that the public protector in the exercise of her powers too would be subject to the rule of law, will be subject to the separation of powers, which is a tenet to the rule of law as well. I do not anticipate any difficulties in relation to that proposition emanating from any of my colleagues. She too would be an organ of state. She too can perform no function nor exercise a power unless so authorized by the Constitution and the law. She cannot instruct Parliament to amend the Constitution, so we know, and I will take your lordships to that judgment which we all popularly know. But I can do no better when I deal with this subject than to refer the court to paragraph 29 of the Public Protector's affidavit that we will find on page 73 of the pleadings bundle. We hold as significant the fact that the public protector appears to concede against paragraph 29 of those papers, where the the public protector makes the following statement. She says, I accept that it will almost always be impermissible for the public protector to require the president to appoint a commission of inquiry or to determine the mode of operation of judicial commissions of inquiry. We think that it's a very significant concession being made there. It is a concession also made in the public protector's heads of argument. But then so says the public protector, however, given two facts, this is an exceptional situation, and cites two facts as a proposition why she would dictate to the president to exercise an executive power. The first reason she offers is that there are resource constraints that make it impossible for her to conduct the investigation, to make the report, and also to take a remedial action. There is no authority for the proposition that want of resources or inadequate resources are a sufficient legal justification not to respect the separation of powers doctrine. So that as a reason does not help the public protector to escape the constraints which are placed on her by the rule of law and a separation of powers. She also gives a second reason for the proposition that she somehow can go and trespass on the areas where the Constitution has allocated the power to the executive. The second reason she offers is that the president is personally implicated in the allegations before the public protector. Why that as a reason can ever offer itself as a sound logic and cogent reason for the public protector to go and trounce on the exclusive preserve of the executive is difficult to fathom. But she too does not offer any reason whatsoever for that proposition. Might I take this opportunity to then address your lordships why she must be wrong, because our courts have had occasion to pronounce themselves on this very issue. In the case that served before this court in the DA matter, September, GP, yes. This is a matter that served before Justice Makume. And it is very interesting to then see what Justice Makume had to contend with. This is an application where the DA sought to compel the president to appoint a commission of inquiry unless, as they contended, there was a court order not to do so. In that matter, Justice Makume had the following to say against paragraph 32, which is on page 54 of the bundle of authorities that we handed up. Against paragraph 32, there is a reference to the earlier judgment. This is the one I think presiding judge you're referring to. And it reads as follows. In the recent unreported matter between South African Reserve Bank versus Public Protector and 5 others, and the case is cited there, a judgment by my brother Murphy J. dated 15 August 2017 the court had to deal with a challenge by the Reserve Bank against the remedial action taken by the public protector. At paragraph 9 of that judgment, the court said the following, quote, despite initially opposing the application, the public protector filed an answering affidavit in which she conceded the merits and consented to all the relief sought. She has agreed that her remedial action is unlawful in that only Parliament has the power to amend the Constitution and that she has no power to dictate to Parliament. Then comes the rhetorical question which the judge asked against paragraph 33. There the judgment reads, the question to be asked is if that is what she said recently about Parliament, will her view be different when it is the President who claims the sole constitutional authority to appoint a commission of inquiry? And says the judge, that question will have to be answered on the 23rd October 2017, which is, well, it should read 24, which is today. The significance of that lies at two places. The one is the public protector appears to consider as a matter of law that there are certain things that the constraints of the Constitution and her powers she can't overcome. And in that matter, she considered that she cannot tell Parliament what to do. And the reason that concession was made was because that power to make laws and to amend the Constitution resides with Parliament and nobody else. And it is difficult to conceive of a different answer when that power resides with the President, as we have seen in section 82(4) F of the Constitution. Of course, it becomes appropriate at this stage then to go to the August judgment to see what Justice Murphy had to say about the separation of powers doctrine. There we would recall that's the South African Reserve Bank judgment, and we propose to deal with paragraph 43 and 44 of that judgment. On the bundle of authorities, we will find those two paragraphs on page 503. Shall we refresh our minds what that matter was about, or what that remedial action was concerned with? But the point of the judgment is, again, the same point, that the public protector does not have the power to offend against the separation of power doctrine. There is another judgment about which there cannot be any contestation, which also makes that point. That's the NEF judgment. It's also part of the bundle of authorities. It's also one of the judgments of the bundle of authorities, and it appears on page 324 onwards. That again is a judgment where the public protector's remedial action included people to pay sorry money and things like those. And the court said she does not have the power to go there. The UDM matter also makes the same point about what the executive powers are, and I will refer your lordships to, and her ladyship, to para 92 of that judgment. On page 521 of the bundle of authorities. The court held that to say about the Speaker of Parliament that a particular vote of no confidence in the President must be by way of secret ballot would be overstepping the mark. The court stopped only at a point where it said the Speaker may have misconceived her powers. She does have the power to direct that vote of no confidence to be open or secret. We emphasize that point to say that too is a judgment binding on this court, which makes it plain that the separation of powers doctrine is good law, still remains good law, is part of our Constitution, and the public protector is also subject to that as a point of law. And the justification which the public protector seeks to give for trespassing on the separation of powers doctrine does not sell. It does not have any authority in law, and there are ample authorities of the judgments of these courts that make it plain that she has no authority to transgress those boundaries. It cannot. And very interestingly, even the court, in terms of Section 172 of the Constitution, is authorized in very limited spaces to go and pronounce itself on the powers of the legislature or the executive. So not even courts are able to go there unless authorized by the Constitution, and there are a plethora of judgments that tell us that to be correct. The other point we want to visit is probably one of the strong points that we want to make in this regard. And it is to look at what the power of the public protector is in terms of the Constitution itself. The reason is bad in law for a number of reasons. The first is lack of resources cannot be a basis to outsource work that which Parliament said it must be done by the Office of the Public Protector. What you could have done, if that was a constraint, was to approach Parliament and say, you must make it possible for me to discharge my constitutional obligation. There must be a special appropriation which allocates adequate funding for me to discharge this obligation. You don't get outside that problem by then outsourcing the work to a structure that's not even there.
What do you mean by outsourcing?
By saying the investigation which the Constitution says must be done by the public protector should be done instead by a commission of inquiry. That is what he says. Now, let us address this point to show that she must be hopelessly mistaken to go down that road. Section 82 has a triad to it. 84 rather, 182. Huh? I keep interchanging the two. Section 182, which deals with the powers of the public protector, has a particular sequence and logic to it. under section 182.1, it identifies it says the public protector, as regulated by national legislation, is to A, investigate any conduct in the affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice. So in very explicit language, we are told her duties are to investigate improper conduct in very specified areas of government. And then says, in most significant way, to report on that conduct. So there is a direct link between what she is to investigate and what she is to do. So one expects when you see a public protector's report, make a report, it must be on the conduct that is being complained about. She must be making a report on that conduct. We know in this instance it's common cause that she did not make any findings at all. She says in the first investigation there are certain indications that show to this, that if correct, and that, etc. She does not make any findings at all. Indeed, because if we read section 182, I beg your lordship's pardon? Yes, she must report on that conduct, which is a factual finding that must be made about the complaint. And it is very significant because B says exactly that, it uses the word report on that conduct. No. May I make a submission that, firstly, if we take A into account, it tells us that it is conduct you are looking into, not the allegations. It is suspected conduct, it is allegations that are made about that conduct, and B then says, you must make a report on that conduct. I.e., it must be conduct which has been found to either be conduct of impropriety, that is what you must report on, or it must be conduct which can result in impropriety or the prejudice. So there is a direct connection between what we find in A and that which we find in B. And then it makes coherent sense to get C, which is then take remedial action, i.e. that remedial action must be a correction of the conduct which has been found to have caused the prejudice or the impropriety or resulting in impropriety or prejudice. So there is a coherent logic that one cannot take a remedial action where there is no conduct of maladministration in terms of the Public Protectors Act, alternatively impropriety in terms of section 182(1)(a) of the Constitution. And we're saying this is pretty significant because, as we will demonstrate with other authorities, there ought to be a correlation or a nexus that the remedial action which the public protector takes it's a remedy against the impropriety or the correction of that impropriety or the correction of that prejudice. And we make the submission that a commission of inquiry does not achieve that result. And we make the submission that until such time as a public protector has found conduct to be improper, until such time as he has found conduct to cause or result in prejudice within the contemplation of Section 182, she cannot even make a report. Because the report which she is authorized by law to make would be a report on that conduct.
The language of the section you read, I think it would be helpful to me. Is it peremptory in terms of the investigation of the report?
It is peremptory, my lord, and it is peremptory because it is a very narrow interrelated connection between A, B, and C. It is inconceivable that, as some of the respondents want to contend, it's inconceivable that you can make a remedial action on conduct that you have found to be lawful. Because what are you remedying? I mean, even common sense would tell us, and I digress a bit, you cannot prescribe a remedy for a condition you haven't diagnosed. You cannot prescribe a remedy for an ailment that is yet to be described. And that's how this language is used in the Constitution. It is a remedial action to cure that which you have found to constitute conduct of impropriety or prejudice. And that point is made very plain in the South African Reserve Bank judgment. There you'd recall that there was never any complaint laid with the public protector relating to the mandate of the Reserve Bank. And then the court said, then you can't go even there. There must be a complaint. You must have found there is something worrying about that complaint. It must be a complaint of the nature that shows impropriety or likely to result in prejudice. And then you can go and take remedial action in relation to it. I may unduly be burdening the court with judgments which I may mistakenly take to be obvious. And the distinction which is sought to be made about whether that case is distinguishable or not is one without a difference. Because on all fours, the Reserve Bank judgment makes the point, and it is a point considered by the public protector. That the constitutional power to take remedial action cannot arise unless, as we call it, the jurisdictional facts are present for the public protector to take that remedial action. But what the public protector does with her remedial action is to say that investigation is one that will be done by a commission of inquiry. But she can't do that, because what she is then doing is to say, whereas Parliament has reposed this obligation and power on me, I will have a commission of inquiry do that. Let me illustrate why that is not even competent. A commission of inquiry is an advisory body.
I think let's not lose sight of the fact what she has recommended about what that commission should find, because she doesn't leave it open-ended.
Yes.
So it's not the normal commission of inquiry that she's recommended. She's recommended that when it's done, within 180 days, you must report to the President, who must then report to Parliament with the reporting. So I don't want us to lose sight of that fact.
The sting of the submission we're making is, can a commissioner of inquiry take remedial action? The answer is clearly no. Now she wants a commission of inquiry, which we say does not have the power to take remedial action, and says take that report and give it to the president to onward it to Parliament. That misconceives exactly what the complaint is. Those who complain to the public protector come there with a strong belief and understanding in law that they're entitled, if the complaint is found to have merit, that there will be remedial action taken on it. And now she takes that power out of the Public Protector Act, out of the Constitution, and says, I'm giving it to a commission of inquiry. Unless we make the submission, a commission of inquiry can never have that power. Apart from offending the separation of powers doctrine, she is misallocating legislated powers under the Constitution and the Public Protector to a commission of inquiry. Now, let us see how that subverts the sequence that is to be there in terms of Section 182. And maybe let me illustrate it even with a higher example. The Executive Members Ethics Act is a special piece of legislation which Parliament has said the public protector must investigate, and it has a process in terms of that act. Section 4 of it will tell us any breaches or alleged breaches of the code of conduct are to be investigated by the public protector and within specified timelines, and if those specified timelines are not met, to get an extension no longer than X, and then to report to Parliament on it. Now, the public protector, by this remedial action, says the breach of ethics must go and be investigated by a commission of inquiry. Where does she get that power? And the submission we make is she doesn't. Because in substance, what then happens is that even the commission can do nothing if it ever found the breach of the code of conduct to be present in relation to a particular complaint. I don't know if I should take your lordship and their ladyship to Section 4 of the Public Protector and look at what process must follow an investigation in relation to that. That would be Section 4 of the Public Protector Act.
I think what would be helpful, I think we've had it so far. Would I in fact sum up your case in this regard in the following terms? The Constitution expects or obligates the public protector to investigate a complaint. Obligates, I use the word. And it also obligates the public protector to make a finding arising from that investigation in a report. And in that report, if she has found wrongdoing, it obligates her to recommend remedial action. I use the word obligate deliberately. Now, your submission says to us she has done none of this, so whatever remedial action she has recommended is not remedial action as understood within that legislation.
That's why, Judge President, we make the point that it is probably one of our most cogent arguments we can make why the review ought to succeed. That her remedial action cannot be unrelated to any conduct which she must make and I couldn't have put it more lucid than you have, that conduct is of a nature that she found points to maladministration, either in terms of the Public Protectors Act, or amounts to impropriety or prejudice, as the Constitution says. Absent that, she can't claim to have the constitutional power to take remedial action.
You use the word points to wrongdoing, points to violation. And actually, again, I repeat the same point. Are you suggesting that she must actually make a factual finding that such conduct exists? What manner of discretion?
Or she's obligated.
Can she really say, I suspect, based on the totality of the evidence that I have at my disposal, that such conduct
No,
which needs to be further investigated?
no. My Lord, let's go back again to 182A. What she is to investigate are allegations or suspicions of impropriety. So she cannot make findings on allegations. She cannot make allegations of suspicions. She can't report on suspicions, or she can't report on allegations. She must investigate those. And having investigated them, she must then make a finding that they point, I'm using that word again, she has found that there is conduct which is improper or which results in any impropriety or prejudice. Because what are you remedying if you haven't made a finding of impropriety? How can you remedy a suspicion? That's the difficulty and the rhetorical question one would ask. It cannot just be a suspicion. If that suspicion is found to be without merit, how can you then take a remedial action? Yes.
That she must report. And that depends on her having investigated that conduct. Is that the circle that you're trying to do?
That is the cycle that I'm trying to allude to. And it must be in that way if she is acting constitutionally. If we find that she hasn't run the cycle as the Constitution contemplates she must, then she's acting unconstitutionally. She's acting unlawfully. And this is what has happened here, because we know a commission of inquiry is not a remedy of any of the complaints that were laid with her. On the contrary, that commission is intended to go and investigate, to do exactly what the law says must be done by her. Well, the first difficulty she has is the whole concept of a commission of inquiry is her own creation. But even on her papers or her investigations, she can't raise that to a level of effect that the president is conflicted. There are allegations of that conflict. She has not made any findings about that conflict she is referring to. And that does not help her survive the constraints that she cannot overstep the mark. Even if the president was convicted, as a matter of fact, that would not, in and by itself, give her powers that she doesn't have. Can I deal with a separate topic? And that is circumstances under which a public protector has the power to delegate her functions. Reading the Act itself, as well as the written submissions of the other parties, it appears to me that we ought to be looking at section 6, bracket 4, small c, and a Roman figure 2, which we find in the Public Protectors Act. And central to this topic, the submission we seek to convey is that the Act is very specific under which circumstances she is able to outsource her powers or delegate her powers for investigation. And we will see something very distinct. Those provisions don't make it competent to delegate as she has attempted to do in relation to this matter, by saying a commission of inquiry must be appointed. 6-4, what is 6-4? 6-4, On the list of authorities, we have page 267. No. The numbering there is an old number, I'm told. But section 6.4, C Roman figure 2 of the Public Protector Act reads as follows. The public protector shall be competent, C, at a time prior to, during, or after an investigation, if he or she deems it advisable to refer any matter which has a bearing on an investigation to the appropriate public body or authority and affected by it, or to make an appropriate recommendation regarding the redress of the prejudice resulting therefrom, or make any other appropriate recommendation he or she deems expedient to the affected public body or authority. Now, that she can do so admits of no debate. But there is a control to this, because once the investigation gets done, it gets back to the public protector to do something about it, to make a finding and report on that conduct and then take remedial action. What it doesn't contemplate is that a commission of inquiry will then take its findings and go give them to the president and then to parliament. So even the process by which that delegation is sought to be done is inconsistent with the language of the Act. So we know she cannot rest on the basis of Section 6.4c, Roman figure 2. That is not what she's contemplating must happen in relation to the Commission of Inquiry. The other remote area where she has the power to delegate, we find it in Section 7(3) of the Public Protector Act. There it reads, the public protector may, at any time prior to or during an investigation, request any person at any level of government. That tells us it's not a commission. Subject to the law governing the terms and conditions of employment of such a person. We know that's not a commission. Performing a public function, subject to any law governing the terms and conditions of the appointment of such a person. We know that's not a commission. Otherwise, subject to the jurisdiction of the public protector. We know commission of inquiry is not subject to the jurisdiction of the public protector. To assist him or her under his or her supervision and control. And we must emphasize that. A commission of inquiry is not going to be subject to her supervision. It is not going to be subject to her control. So she cannot purport even to do it in terms of Section 7(3) of the Public Protectors Act. Now, in our submission, therefore, the public protector must tell us where she derives the power that an investigation submitted in her office must be investigated by somebody else. And the two areas that the Act contemplates are areas where it is a particular entity that is identified, a public entity, that is going to do that investigation or part of the investigation and then report to her. And as we make the submission, she too is bound by the Constitution to the extent that she can perform no function or exercise any power unless that which is located in the Constitution or the law. So those two areas cannot clothe the public protector with the power to have the investigation submitted to her be done by an entity other than those contemplated in the two sections. And the Commission of Inquiry is not one of them. And she does not have that power in terms of Section 182, neither does she have it in terms of the Public Protector Act. And for that reason alone, her remedial action stands to be set aside, reviewed and set aside. I propose to go to another area. Would this be a convenient time? It's okay. I was going to start on a subject, but we do.
Which subject?
No, there's still another element about the remedial action which I seek to address. Just you would recall that the public protector, having made the concessions that they have made, they then seek to say there are statutes, and in this instance, there are statutes that make the exercise of a power have a duty to it. And they rely on the Van Rooyen judgment for that proposition. They're mistaken, again as a matter of law. What the Van Rooyen judgment concerned itself with was the question of recommendations by the Magistrates Commission. That if a Magistrates Commission recommends that a magistrate be suspended, the President has the power, the Minister has the power to take that recommendation to Parliament. And that judgment then says, in such circumstances, there is a duty resting on the individual holding the power to do so. And that is understandable. If there is a power to issue a license and an applicant meets the requirement for the issue of a license, then the duty arises that the functionary must issue that license. There are no difficulties with that as a proposition of law. It does not apply in this instance for at least two reasons. There's a judgment of the Constitutional Court, the Daniel judgment. It is page 36 of the bundle of authorities. And to read paragraph 1 together with paragraph 12. Paragraph 1 says the court, and it gives us the context within which section 84 2F is to be construed. There in paragraph 1, the applicant, Mr. Frederick Kundrat Daniel, seeks an order setting aside an earlier order issued by this court. This application is a sequel to the application lodged in this court by the applicant under that case number. In that case, the applicant sought an order declaring that the President's failure to appoint an independent commission of inquiry was inconsistent with the Constitution. In addition, the applicant sought an order directing the President to establish the commission within 10 days. Although the court there was concerned with the question of its exclusive jurisdiction in terms of 167, it makes a very telling element about the nature and content of the section 84.2 power. It says against paragraph 12, drawing from Doctors Life, Doctors for Life International, this court in Van Abo, President of the Republic of South Africa, held that obligation in section 167.4E means a duty specifically imposed on the President to perform specified conduct. Examined in this context, section 84.2F does not impose a duty on the President, but a power which may be exercised at his discretion. Accordingly, the President's failure to appoint a commission of inquiry does not amount to a failure to fulfill a constitutional obligation. We're saying, even though addressing the question of exclusive jurisdiction, the court was alive to the fact whether or not there is an implied duty in section 84.2F of the Constitution. And what it says against that paragraph is that that is only a power and not a duty. But the other settled difficulty with the contention which is sought to be advanced by the respondent, it is one that is measured against her own concession that she does not have the power to do it. Ordinarily, she uses the word. And one wonders why the word ordinarily would then clothe what she does not have as a power under the Constitution or under any law, to then clothe it with some legality. Would we be convenient now?